Hello, this is Jonathan Wabarucha. As chair of the Environment, Energy, and Resources section of the American Bar Association, I want to welcome you. This is one of the first podcasts in the new ABA year. SEER is committed to providing timely, important, and informative content to our members. Today, you will hear from former SEER Chair John Cruden and longtime contributor to the section, Professor Lisa Heinzerling. They will discuss recent Supreme Court rulings and the impact that will have on the environment, energy, and resource legal and policy sector. I hope you enjoy this podcast and the many podcasts to come this ABA year.
Welcome to a podcast on an interesting, puzzling, and very lengthy opinion by the U.S. Supreme Court this immediate past term, Loper Bright Enterprises, Inc. versus Raimondo, and the fate of the deference doctrine to administrative agencies, once known as the Chevron doctrine. I have with me two stellar speakers, and I use that term with deliberate consent. First is Professor Lisa Heinzerling, who holds an endowed chair named for Supreme Court Justice William Brennan, for whom she clerked. Her primary specialties are environment and administrative law. Professor Heinzerling has a distinguished career in the environment and energy resources area, notably including author of a lead brief in a small Supreme Court case called Massachusetts versus EPA. She's also worked on the administrative agency side of things, including serving as senior climate policy counsel to the administrator of EPA and also as assistant administrator for the EPA Office of Policy. Along with Professor Heinzerling is John Cruden, who is now a principal at Beveridge and Diamond. He was a past Senate-confirmed Assistant Attorney General for the U.S. Department of Justice Environmental and Natural Resources Division, which handles all of the representation of EPA and other administrative agencies related to the environment and natural resources. John is past president of the Environmental Law Institute, the American College of Environmental Lawyers, and a past chair of this section. He is also an adjunct professor at George Washington University. What makes these two people so spectacular and stellar is that both of them have been leading lights in the energy and environmental field for decades. But they're not only leading lights, but they're passing the torch. Professor Heinzerling has won a distinguished award, the Frank Flagel Award, for teaching younger students. John Cruden has been teaching people both in the section at GW Law School and throughout his many years to value the environment. So with those items as background, I'll proceed to our case du jour, Loper Bright Enterprises, Inc. And my first question to Professor Heinzerling is, who comprised the majority in Loper Bright and what did they decide?
Well, it was a 6-3 decision. The 6 conservative justices comprised the majority. Chief Justice Roberts wrote for the court. What did they decide? Several things. The first, they made it unmistakably clear that they were overruling Chevron. There can be no doubt. If Justice Gorsuch some years ago said he wanted a tombstone no one could miss for Chevron, the court delivered that in this case. The second thing the court did is to explain a bit, not a lot, but a bit about what interpretive principle would replace Chevron. And I think most simply stated, the principle is that judges decide, not agencies, judges decide what a statute means. And what they're looking for is the so-called best interpretation of the statute. so that it's not only the personnel were chosen by the Supreme Court, and the personnel are the courts in deciding these legal questions. And the way they go about it is they're looking for the single best interpretation of the law. And in doing that, they're supposed to use all the tools of statutory interpretation. Of course, one of the issues that's always dogged Chevron itself even is that there's not a uniform consensus about what exactly is the best way to interpret a statute and what are all the tools. Some justices and some judges rule out some tools like legislative history, other judges rule them in. And so this decision is unsatisfying in the sense that it doesn't help us to answer that question. There is a small detail, though, that I want to mention in the case that may not be noticed by everybody, which is that the court itself relies on legislative history in a case overruling Chevron and coming to a new understanding of statutes. Does that matter? Not sure, but it's a tantalizing detail, perhaps, for those of us who think the court has gotten too narrow in the tools it uses for interpreting statutes. And so how does the court do this work? How does it decide to overrule Chevron and to say that there's a single best interpretation and that should be the one that's embraced by judges? Well, one, it states a legal basis for overruling Chevron and for embracing judge-made interpretations. And that is quite remarkably, I will say, Section 706 of the Administrative Procedure Act. And what the court says is that section, insofar as it, in its little chapeau or preamble, the paragraph before it gets to the standards of review, the APA provides that reviewing courts shall decide all relevant questions of law. And the court seizes upon this and said, this makes Chevron not only unwise, bad policy, whatever, then it makes it unlawful, and it has always been unlawful. So there's part of what the court is doing here, I think, is really trying to make the reader believe that there's nothing very major going on because it always has been thus. So that the APA since 1946 has forbidden something like Chevron. Even before that, the courts didn't embrace any kind of deference principle like this. And so there's this sort of, it feels very, for somebody who's really steeped in administrative law, it feels not quite right, at least to me. The quite long section of the opinion that describes how we've always been doing this and that Chevron itself was an outlier that first appeared in 1984. So the court also talks about expertise some and talks about how it's actually the courts who are the experts at interpreting the law. And yet it also talks about fact finding. So there's a way in which it ranges over a lot of legal territory and seems to say, yes, there can be a lot of respectful attention on the court's part to the agency's fact finding, but not so much or maybe any to the law, that the courts can respect the agency's judgment, but that the courts, in my opinion, this is the way I read the decision at least, the courts are always the ones making the decision. If they don't agree with what the agency has done, then not only they should, but must undo what the agency has done. Very formalistic kind of understanding about law's relationship to policy, the clarity of law, the single meaning kind of valence of statutes and so forth. So just a couple of other points I'll make in this opening kind of description. The court did allow, again, in some circumstances, respect for an agency's view. It's not clear this is anything other than the agency doesn't always lose. It's what it feels like a little bit, especially if it's contemporaneous and consistent, then the agency might get respect. Of course, what is the opposite of respect? Disrespect. Right? And so that's sort of funny that the court has to reach out and say, oh, but sometimes we'll respect the agency. What is the court's job left to do? It is to set the constitutional limits. It says this a couple of times. Remember that the court hasn't yet decided whether to revisit the non-delegation doctrine. I feel like they're gesturing when they talk about constitutional stuff and courts setting constitutional limits. I feel like that might be what they're gesturing towards. Courts set the boundaries of the relevant statutes, and they enforce reasoned decision-making. So it may be, the court says, that a statute gives an agency a range of discretion, but courts are still there policing the boundaries, both constitutional and statutory. And last, you might be wondering, what happens to all those cases that were decided in all those years, right? What is 70 at the Supreme Court, 18,000 in the lower courts? What happens to those cases? Here the court says, don't worry, it's no problem. Those cases are safe. It only cites its own cases. So one imagines, at least for the majority that was assembled on that day when Loper Bright was decided, that precedents under Chevron Step 2, affirming an agency's decision or interpretation under Step 2, that those are safe, seems like. But all those thousands of lower court decisions, not so much, right? It's not, the court didn't even mention them, didn't talk about the lower courts, and of course the lower courts are free to do what they want to do with their own precedent. We've already seen some of the circuit courts wrestling with the question of what to do with their own precedent in the new circumstances. So I think I'll stop there.
So now we're turning to John and asking for what Tom Cruise might have dubbed the Minority Report. Can you talk to us a bit about what the dissenters' arguments were and how they framed those arguments in response to the majority?
Thank you, Norm, and thank you for putting this together for this listening audience. Norm Dupont is one of the great environmental lawyers of our lifetime, so it's a real pleasure to be with you, Norm, and then Professor Heinzerling is a longtime friend and a scholar who I admire because she also has such a great practice of her own. All right, let's turn to the dissent. This is like the other side of the story. This is Justice Kagan writing for the three members of the dissent, and she has those dissenters have gotten a lot of experience lately, particularly this term, writing dissents. And it's an angry dissent. It's a dissent written by an administrative law professor. She starts out by saying that 40 years of Chevron has been a cornerstone of administrative law, allocating responsibility for statutory construction between courts and agencies, applied in thousands of decisions. So she sets the stage of saying what has happened here is overturned, settled law for decades of experience. And it's probably true of everybody in the audience. I'm confident in your administrative law class, if not your environmental class, you know the Chevron two-step dance. You know that, and you know all the different parts of it that have Chevron step 0 and so forth. All of those are sort of embedded in our brain because it's come up so many times there. So she starts with indicating this is not a small deal. This is not insignificant. This is changing settled law. And then she argues that essentially the majority have flipped the script. That's what she calls it. You have flipped the script, and you're now giving courts the power when Congress really left open an area of interpretive discretion for the executive branch. And so she begins her dissent, again, talking about flipping the script. And then, because this is not her first dissent, she points out that in recent years, the court has too often taken for itself decision-making authority that Congress has assigned to other agencies. And she cites that to a case that many of you are familiar with from last term, the West Virginia case, which dealt with Clean Power Plant, and says this makes the court an administrative czar and says the majority disdains restraint and grasps for power. She takes on the majority. The majority had made a number of points that Professor Heinzerling set out. The agencies don't have any special competence and that an ambiguity in the law does not necessarily reflect a congressional intent that agencies should have primary interpretive authority. On that point, by the way, she rather agrees that not every statute that has ambiguity necessarily means that Congress gave interpretive power to an agency, but says that's why we have presumptions. This was a presumption that by creating ambiguity that Congress was allowing or even suggesting, in some cases, perhaps even mandating, that the agency fill in the blank using their own expertise. The second part, she has several parts of her dissent broken up into it, which I'm only briefly summarizing. Her second part deals with the Administrative Procedure Act. She points out the anomaly, which you'll all agree from the start point. Remember, the APA is 80 years old, so it is much older, of course, than the Chevron decision, and somehow the majority, she says, only now found out, years later, that the Administrative Procedure Act trumps Chevron. So she points out this the Section 0706, which Professor Heinzerling's already talked about, requires deferential review for fact-finding, but it's really silent on anything dealing with deference, so it's very hard to say that somehow the authors of the Administrative Procedure Act were eliminating the possibility of a case like Chevron. She spends an entire section on stare decisis, and as I said at the beginning, she's pointing that out right away, that this is significant. This has been a case that's in effect for over 40 years. And she says that the primary issue on stare decisis is something she calls a jolt to the legal system. And she says this is a jolt to the legal system, and gives a long section dealing with why stare decisis is not applicable. And then finally, she argues that decision gives power to the court to make all manner of scientific and technical judgments, and it's likely to produce large-scale disruption. I just want to read a few sentences from her conclusion because I think it's a good summary of the position of the minority. She says, at its core, Chevron is about respecting that allocation of responsibility, the conferral of primary authority over regulatory matters to agencies, not courts. Today, the majority does not respect that judgment. It gives courts the power to make all manner of scientific and technical judgments. It gives courts the power to make all manner of policy calls, including about how to weigh competing goods and values. So it is an angry dissent. She indicates that this is going to cause a significant amount of disruption in the future, and ends on that basis, Norm.
Great. Well, I have a question for both of you about the road not taken. And starting in the Chief Justice's opinion in Section 2A, he seems to talk about constitutional types of issues. And then he veers off into a little bit of history about the New Deal. And then he turns to the real basis for the majority's opinion, which is a statutory basis of the Administrative Procedures Act. So I ask both of you, what about the road not taken, the road urged by Justice Thomas in his concurrence opinion of a constitutional, Article 3 powers given to the judiciary type of analysis? Lisa, maybe you could start?
Yes. And I want to start just by mentioning something that you alluded to and turn to the road not taken, if I may. And just that's one of the things that really struck me about Chief Justice Roberts' opinion here is how messy it is compared to his usual decisions. I mean, whether you agree with them or not, his decisions usually are like Swiss watches. Like every part fits, it works, it's beautifully worded. There's something about it that feels inexorable. I didn't find that about this decision at all, and partly for the reasons you mentioned, Norm, which is that there's a way in which it starts off with this real feeling of an adjacency or maybe even a dependence on constitutional norms, right? And with the way we've always done things and the things that courts do. And then suddenly we're in 1946 talking about the specific language of the chapeau in the Administrative Procedure Act. And so I found that interesting. So I have a couple things to say about the question about the road not taken that sort of relate to this, what I think of as this messiness. So on the road not taken, that is the idea that the court itself, the majority, did not say that Chevron itself was unconstitutional, even though Justice Thomas did. Justice Thomas thinks that it's unconstitutional because it takes power from the courts and gives power to the executive. In both of those ways, he thinks that it's not constitutionally sound, and the court doesn't say that. And that may be important. Why would that be important? Because the APA is a statute, and statutes can be changed, and the court inserts its usual boilerplate about, well, we're very happy and gratified that Congress can change everything we've done, right? And so there's that boilerplate, and they've relied on a statute. And so one possible meaning of that, the road the court did take, is to say, this means that Congress could adjust the interpretive principle discussed here, could give some of that discretion or deference back to the agencies, either on a case-by-case basis or wholesale, what have you. And so that's one possible meaning. I am not as sure of that possible meaning. I'm not saying it's not worth trying. I know that there are people thinking about what Congress can do in response to this decision. But I was struck, as you were, Norm, by the opening, because what the court seems to be saying is deciding what the law is what courts do. That is just what courts do. That's what they've always done. That is what they must do. No one else may do that job. And in that light, then, it begins to feel of a piece with another major decision in recent years, the West Virginia case that John alluded to, which is, of course, the case that crystallized this idea that if an agency is addressing issues of great economic and political importance, Congress has to have spoken clearly to have them be able to do that. There, too, the court just nudges toward, just says serious constitutional concerns, right, or separation of powers concerns. And so I just think this is part of Chief Justice Roberts' toolkit, which is to be coy, to gesture towards constitutional problems and then kind of move away from them. And so what it does is, I don't think it gives final comfort to people who would like to have a legislative adjustment. I think it's more like a sword of Damocles, right? That he didn't have to say anything about it here, so he's not going to, but it's always out there. It's always out there.
John, your thoughts?
No, I will add that, we have to remember that Thomas wrote actually rather short, 4 pages, indicating exactly what you just heard from Professor Heinzerling, that this is a constitutional case. However, he was the only one. He was the only one. You don't have anybody joining him in his dissent. And he cites to a lot of his own dissents in support for all of that. So this is sort of Thomas on constitutional law. And Thomas tends to find a lot of places where constitutional law applied. What I didn't say when I was covering Justice Kagan's dissent is she points out that over 40 years, Congress had multiple opportunities to disagree with Chevron if they wanted to. And of course, they did not do that. So even though Thomas very specifically says that I'm joining in this opinion, I agree. However, and he's very specific, Chevron says requires abdication of Article 3 judicial powers and permits executive branch to exercise powers not given it. And so he says that, Chevron was a 40-year misadventure. That's what he calls it, a 40-year misadventure. But I certainly agree with Professor Heinzerling that this opens up the possibility, because you could change the Administrative Procedure Act that would provide something like Chevron deference. But I'm always amused right now, because we hear that all the time, that we could correct the statute, or we could correct that decision by having Congress act. I would not mortgage my house and put my money on a bet of Congress somehow fixing that decision or most decisions there. But I would say again, Thomas was speaking alone when he talked about this being a violation of separation of powers. No one else agreed in that decision.
And just as a very brief follow-up, Justice Gorsuch, when he was on the 10th Circuit, wrote a very famous concurrence to his own majority opinion in an immigration law case, saying that there was a constitutional law issue, the, quote, elephant in the closet. But in this case, I did not see Justice Gorsuch raise the constitutional issue. So I'm wondering why he ducked. Do either of you have any thoughts?
I don't know. He was awfully busy writing over 30 pages of opinion on why this does not violate stare decisis. I'm not quite sure why he felt a need to do that, but he certainly did do that. Thomas doesn't even join that, but he writes in his own opinion. Well, I agree with some of what Justice Gorsuch said, but it was sort of amusing to me that he did not join in that decision as well. But I don't know. Lisa, what do you think?
Well, and also I would point out Justice Gorsuch is one of the people who has been quite forceful in calling for a revitalization or a vitalization, depending on your point of view, of the non-delegation doctrine. So I don't know that we can take too much from him not joining Thomas or think that he's backed off from some of his positions about the fundamental unlawfulness of the administrative state. But it is curious. It is a curious fact that he didn't join. They seemed like they might have been kind of buddies in their dissents, and they ended up not being.
Let's move to another sort of big set of issues for all those in the audience who may be less cognoscente of the exact words of the case and wondering what they do on behalf of either an agency, an NGO group trying to either support or attack an agency's decision, and what Loper Bright and its cognate case, Relentless, Inc., potentially mean for advocates in the future. John, could you, as a former advocate who represented federal administrative agencies, give us a few words?
Joke that on our screensaver at Department of Justice, where everybody else had their wife and kids, we had Chevron because we knew we were going to cite it sometime during the day. But that said, as Roberts pointed out in his majority opinion, that Chevron had not been used by the Supreme Court since 2016. So in another presentation that I gave, I called, at least in the Supreme Court level, that Chevron was a bit like Lord Voldemort in the Harry Potter series. He who should not be named. Because, again, for a pretty long period of time, Chevron not only was not used by the Supreme Court, it wasn't used by advocates because they knew that it was on thin ground. That said, as Kagan pointed out in her dissent, a lot of Court of Appeals did that, and those of you in the environmental community know that Clean Air Act in particular generates a lot of statutory issues, and the D.C. Circuit has long relied on Chevron. So it is a major decision going forward. I've said that if I was back in my old chair at Department of Justice, I would do one of those search and replace things that you could do on your computer. I would search for Chevron and I would replace it with Skidmore there. Skidmore is a 1944 decision that gives the power to persuade. It does not mandate. And frankly, there's not a lot of jurisprudence in that area, largely because it got overtaken by Chevron. But Roberts cites to Skidmore 5 times in his majority opinion. And so it is, without question, of some significance there. It is more significant if, in fact, the agency can prove that they made an interpretation of that statute roughly at the same time as the statute has come out. And, very importantly, they haven't changed that. And that's the one thing that I think Loper really has an impact on, and that is agencies changing their mind. Because, and by the way, that happens all the time. A new administration comes in. We've seen that in countless cases, and that's what Chevron allowed to happen. Chevron allowed that to occur, that agencies could change their position. Scalia, writing in a law review article for Duke, said that's one of the advantages of Chevron is that it allows agencies to change their mind. I think that right now is probably gone now. On the other hand, if an agency can show that it's acted well, that it is, and this is important for Skidmore deference, that it's acted within its lane. It's within an area that it has jurisdiction, and it's an area where they have technical expertise. And if they have had a consistent interpretation of the statute, that's going to help. That's going to absolutely help them find that out. The one area that we really haven't talked about is there a way that agencies can still get deference? And the answer is yes, if the agency was given that authority by Congress. That hasn't occurred that much, but now you probably will see more looking at that. And that's not an area that Congress could do easily. Congress could very easily say, not just environmental issues, anywhere that we're really looking at an agency to, write a regulation that fills in the blanks. Again, it hasn't occurred very much, but it could occur more in the future. The last point I will make for government people listening to this is it's always been important what the administrative record says. That's always been important. I used to say you live or die by the administrative record. If you combine this case with another decision that came out this term, decision dealing with the stay request for the good neighbor rule, where the court granted that stay because they said EPA had not adequately addressed the comments in an administrative record, that makes the record even more important. So I think the government's going to have to do a better job showing that they're operating in their lane, that they have the technical expertise, and that this is a fair and reasonable rule. But there's no question that it is more difficult now after Loper decision.
Lisa, your thoughts, and perhaps also thoughts about what happens if you're representing a state or an NGO challenging an administrative decision these days?
Yeah, so I think these will probably be fairly straightforward points, most of them, but I sort of gathered them all in one place. So some of them refer to things that we've already alluded to. One thing that I think everybody should do, who is, even the government, but certainly people challenging agency action, is really bring out all the interpretive tools, right? Really bring them out. As I mentioned, this case mentions legislative history, bring it out. Another case, I'm blanking on the name, but another case this term mentioned policy of all things, right? Or purpose of all things. So I think it's time to sort of see whether, at least to test the waters, about whether the textualism is as doctrinaire as it was some years ago, and to use all of the possible tools of interpretation. Another, I guess, tip is that maybe a lot of Chevron, I think, pressed people to fit legal issues into the interpretive box because it was so powerful, right, when it was deployed. And there was always a great deal of uncertainty or confusion about what was an arbitrary and capricious question, right, a failure of explanation, and what was a step 2 question under Chevron. That is not only a failure of explanation, but one that went to the underlying statute. And I have to say, even in Massachusetts versus EPA, when I was drafting briefs in that case, it wasn't entirely clear to me which one that case was, right? We framed it as an interpretation case, but a lot of these cases can be, depending on how you sort of squint at them, they can become a case about agency expertise and the reasoned explanation, or they can become a case about statutory interpretation. And maybe this case will press at least some litigants to move into the arbitrary and capricious box and out of the interpretive box. On the other hand, John just mentioned the good neighbor case, Ohio versus EPA. If you do that, then you are then also sort of grappling with a bit of a new world. So the Supreme Court, obviously, Loper Bright got so much of the attention, and rightly so. It's a foundational question, really old case, very influential, and all of that. But if we're in a world where the agencies can no longer rely on deference to their interpretations, and we might see somewhat more attention to how they explain themselves, and I think the Ohio case is quite threatening in the sense that the court worked really hard to find that the comments had actually raised the issue presented. And notice, too, this is a nitpick of mine, but I can't let it go, which is it's not the question presented. The court created the question in the case. This is a case on the emergency docket. It came to the course a mess with like 5 different petitions. They didn't have a question presented, and they went ahead and decided what the court had written for them. And there, I just think the court took a very strict look at exactly what the agency had said. And so that those are the same eyes that are going to be, imposing scrutiny on agency rules going forward. So there's some worry, in my mind at least, about the stage of a reasoned explanation. Another possibility, a lot of people have been talking about this, but I mean, there is a way in which if Chevron was characterized, maybe overcharacterized, but at least somewhat characterized by its even-handedness across administrations, an administration could get deference, whether it was in a Republican or a Democratic administration. There are a lot of rules that were affirmed, and probably a lot of environmentalists, let's say, don't like very much. And also going forward, there will be such rules. And so there's a way in which, if this new world is even-handed in the way I'm describing Chevron, at least at its best, then the reversal of it also is. And so it may be that people can take advantage of this and try to attack some rules that aren't consistent with their interests. Another piece of this is this idea about changing interpretations, which we talked about. And I'm puzzled by this, frankly. This is a piece that's just very strange to me. So there's a whole line of separation of powers jurisprudence that we're not talking about today, but it's also part of the Supreme Court's emerging jurisprudence on separation of powers. And in that line of authority, the court is saying the president is basically the head of the entire executive branch. All the way down, the president has to reign supreme. That's what the separation of powers means. And so that means in practical terms that the president has the power to fire a whole lot more people than the president used to have the power to fire, right? Well, then you turn to this case, and to the extent that it is at least adjacent to constitutional concerns and the separation of powers, it's exactly the opposite. You can fire people, Mr. President, but you can't make them do anything important, right? They can't interpret the law consistently with their own campaign, their own promises. They can't change anything when they get into office. It's just a very strange. So I don't know. One piece of advice might be don't change your interpretation, but I just don't know how far the current quite new hostility to presidents making a difference will go on this court. Just not sure.
I would add just one, because I think this is a really good point, fascinating point. But this decision is a double-edged sword, and there's people writing on that, which means it applies to every administration. So another administration coming in, I don't care who it is, Republican or Democrat, they all come in with new ideas, the new things they want to do, and new executive orders are going to require regulations. They have to deal with that. If another administration comes in and has a deregulation goal, which you can have, that's rather normal, they will also have to fight through what Loper means in a deregulation arena. And so we have yet to see how this will play out over the courses of administration changes, but we're going to see something like that probably coming up in the relatively near future.
Sort of bigger question, and part of it stems from Justice Gorsuch's concurring opinion. There were a lot of amicus briefs, including that by Professor Williams at the University of Michigan and others, talking about stare decisis. And Justice Gorsuch has some very interesting language about stare decisis. Later courts must appreciate, like anyone else, judges are innately digressive, and their opinions may sometimes offer stray asides about a wider topic that may sound nearly like legislative commands. But these digressions may sometimes contain valuable counsel. They remain vapors and fumes of law. And for both of you who have been involved in citing precedent for decades, mere vapors and fumes of law? Are we to really take Justice Gorsuch at his word, or is that just a token throwaway when really he's going to insist that opinions he authors remain solid and valid. So perhaps, Lisa, you could start?
Well, I have a candidate for a very significant vapor and fume that turned out not to be that. The major questions doctrine. That's the way it started. It started as just sort of an add-on explanation. Why did the Food and Drug Administration err when it interpreted the Food, Drug, and Cosmetic Act to allow the regulation of cigarettes? Among other things, almost as a parenthetical, the court said, and it's a really big question. And then it sort of doubled down again in the utility error regulatory group. Same thing. And suddenly, when we get to West Virginia, that vapor and fume has become a doctrine, right? Not only a doctrine that's like an interpretive rule, but a constitutionally inflected doctrine. So I wouldn't take Justice Gorsuch's aside to the bank at all.
John?
In some level, it's beauty is in the eye of the beholder. And so Gorsuch is writing and saying that we were not only right, we were compelled to overrule Chevron because, as Thomas says, it was 40 years of misadventure. But he obviously feels troubled by that. It feels probably challenged by the dissent by Kagan, who speaks at some length about stare decisis and its importance and what it's going to have. So again, writes 30 pages defending all of that, but at the same time, leaving it quite open that, we could change our mind if in fact we think that the prior decision was wrong, as he felt that this one was wrong. My guess would be he does not feel the same way about many of his decisions that he wrote. He would feel those as intellectually superior and desperately need in terms of all of us following. And so it's just rather interesting. By the way, this decision came out at the end of the term. This is one of the very first terms that I've seen in a while that have gone past the normal set when they leave. And I think it's because so many of the justices were writing concurring and dissenting opinions that it just took them longer than the normal term.
For those in the audience, I commend reading a short opinion by Justice Robert Jackson, the Skidmore case, which is all of perhaps 6 or 7 pages long. And I also commend reading that part of the case that decides what the agency doctrine was. It wasn't a rulemaking. It was an agency guidance document by the Department of Labor that got the judicial deference. And indeed, in Skidmore, and Justice Jackson makes it clear that there was not a specific regulation in the statement in the guidance document about this particular group of people, but there was an analogous group about nurses waiting for and having waiting time for their jobs. So a very short opinion by a magnificent judicial writer, in my view, that's probably worth all of us rereading. We're sort of coming to the end, so I'd like to ask each of you final thoughts, clues for the future. Lisa?
This was a momentous term, needless to say, and it looks like the next term will also involve a number of big issues in this area. And I think we just talked about this one piece of the administrative law landscape in the Supreme Court. And I guess I would close by just pointing out the larger context again and how the court is remaking the structure and powers of government, the interpretive frameworks for agency action, even the kinds of reasons agencies need to give in order to act. And so I think this is creating in the short term, I think it's creating, I don't know if I'd say chaos, but certainly it's destabilizing, right? To have this amount of change on this many fronts at a time when we have so many problems. So it's just, we can do all the doctrinal analysis and the case parsing and so forth. But I guess I just want to say this has been This kind of uncertainty, unpredictability, change, distrust of government, really, it has consequences, and those consequences are going to play out in the courts and in the agencies for some time.
John?
Norm, in closing, I have 3 points I'd like to make. First of all, you urged us to read Skidmore, which I heartily endorse. The other case that you should read is Kaiser versus Wilkie. Kaiser versus Wilkie is dealing with our deference. That's a deference given to agencies for their own regulations, both the majority by Roberts and the minority by Kagan. Kagan wrote that decision, cite to that. And it also, to make a point that Professor Heinzerling was made, to have our deference. Our deference, in fact, is a big question of whether or not it still exists in its full form after the Loper decision, but nevertheless, it is worth reading. So that's my first point. The second point is you need to read Loper Bright in the context of a whole series of other decisions coming out by the Supreme Court right at the end of the term. And they're all administrative law powerhouses. We've already mentioned Loper. We've already mentioned Ohio versus EPA, which is the Clean Power Plan, but there's others. Corner Post, which opens up regulations that we thought were already settled. They've opened some up in instances where you can, in fact, challenge them now. Or Jarkissi, which puts at issue administrative law decisions in administrative law judges. So you have to look at what's happening in administrative law, not just with this case, which with the other decisions coming out. And then finally, though, another point, though, just for you who are law students listening to this is a interesting time because there's so much happening that's new. You who are law students are going to be involved in interpreting some of these statutes and some of these regulations that we're talking about. No matter what you think about the good or bad of each decision, it's an exciting time to be an environmental lawyer. It's an exciting time in our profession because things are happening and they're going to continue to happen, which means the practice of law, particularly the practice of environment, energy, and resources law, to be something that we should all be proud of and involved in how these things are going to be interpreted in the future.
I want to thank both of our stellar speakers for contributing their time to once again enlightening and simultaneously passing the torch onto the next generations of environment, energy, and resource lawyers. This has been a remarkable dialogue on one of the great blockbuster administrative environmental cases for this term, and I thank you both for contributing.
We hope you enjoyed today's episode. To learn more about our section, please visit our website at americanbar.org/enviro. Please check where you found us for future episodes. Thank you for listening.